Welcome to this episode of our special series, 7 Minutes with Vivek Sood, with Supreme Court Senior Advocate and country's top legal mind, the man who coined the expression, the fundamental right to internet. Today we will discuss the subject of creases in money laundering law. Welcome to the show, sir. Straight to the first question, what's the importance of PMLA?
Money laundering is a very serious crime that has been recognized across the world, including the United Nations. Money laundering, in sum and substance, is parking of proceeds of crime so that the law enforcement agencies are not able to expose it and get that money in the economy. So it is concealment of proceeds of crime. Now it has become a very serious crime across the world. Across the world, governments have woken up to money laundering. Hence lies the importance of the PMLA, that is the Prevention of Money Laundering Act that we have in India. In my view, it is amongst the most significant statutes for the Indian economy, because this clandestine parking of proceeds of crime and projecting it as legitimate is a serious matter, and hence lies the importance of the PMLA.
Right, sir. Supreme Court has upheld the law. What's your view on this? Do you agree?
I would agree with the Supreme Court, given the importance of PMLA for India. Now, economic legislations, Ajay, are always experimental in nature. Therefore, the legislature must be given free play in the joints while legislating economic statutes like the PMLA. There are bound to be creases, but you cannot say that the PMLA or many of its provisions are unconstitutional. There is a presumption of constitutionality of a statute. After all, the parliament that represents the will of the people has legislated the PMLA. And unless there is some manifest arbitrariness, a law is not struck down as unconstitutional. So therefore, I would agree with the Supreme Court upholding the constitutional validity of the PMLA. Having said this, I must admit and acknowledge that there are creases, there are problems in the PMLA which the legislative policy makers, I'm sure, will iron out. So these creases will be ironed out in future by the legislature, and then implementation of the law is by the executive, by the ED or the DRI. But eventually, all these cases come to the court. So the courts will also iron out many of these creases.
Right, sir. What are the problems do you see in the present PMLA law, sir?
I will not be able to go into details because, the time is short.
Right.
But the two problems which I see in the PMLA, which should be ironed out. The creases ought to be ironed out. One is the bail provision. In my view, after 3 decades of experience, I can say bail justice, even in PMLA cases, should be left to judicial wisdom. Rather than putting conditions in the grant of bail that only when the accused is able to prove his innocence will he be eligible to be granted bail. It may be difficult for an accused to prove his innocence before the trial has begun. So there may be cases where many an accused who are found innocent later on during the trial, they may have been found to have been incarcerated for a long time because of the strict bail conditions. In my view, these conditions need to be mollified. The rigors of the bail provision, section 45 of the PMLA, must be mollified by the legislature itself. Secondly, the judiciary must ensure that the law is not misapplied or the law is not misused by the law enforcement agencies. So that's where the judicial check is necessary. Then, there are some provisions where there is some opaqueness. For example, once an FIR, once that ECIR is registered, a copy will not be given to the accused. So there is some element of opaqueness when PMLA is invoked by the law enforcement agencies. There also the legislature should step in and grant a little more transparency to the accused. Of course, not at the cost of effective investigation of PMLA cases. PMLA cannot be treated like any other criminal statute. It is different. So you need different provisions in PMLA. But some of these creases, I'm sure, will be ironed out by the legislature in due course with experience.
Right, sir. Are you looking at particular solutions, sir?
Some of the creases which I just mentioned should be ironed out by the legislature itself. Now, having said this, in my view, a heavy onus lies on the judiciary to ensure that the law is applied for the purpose it was legislated and innocents are not harassed or innocents are granted relief, whether it's bail or discharge or an acquittal. So a heavy onus will lie on the judiciary to ensure the fair implementation of a strong law, that is the PMLA.
Thank you very much indeed.